Good afternoon. We are here in case number CACV 210494, Sanders v. Springfield. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. You will notice Judge Thama is not present this afternoon. He is out as a precautionary measure, having had potential exposure to illness, and so, but he is watching remotely and will field any questions he may have through us via email, and we will be paying attention for that. We did, first of all, you do know that each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. We did read the briefs, obviously, and conference the case this morning, including with Judge Thama. So with that, counsel, you may proceed.
Chris Hill for the plaintiffs and appellants John Sanders, Lori Venberg, and Robert Sanders. Good afternoon, and thank you for the opportunity to present oral argument on the deciding issue of this appeal, which is whether remedy or reformation of the release agreement can or should be applied. I'm going to provide 5 reasons why the remedy is not applicable under the circumstances of this case. The first 3 reasons, I think, speak to the procedural in substance and the invoked due process concerns, and I think prevent the court from even considering the merits of reformation. The first reason is that mistake and reformation are claims that must be pled in a complaint or as a counterclaim in a defendant's answer. That's under Rule 9b of the Rules of Civil Procedure. In other words, mistake is not an affirmative defense. Springfield has filed a motion to dismiss in lieu of an answer. Thus, it is not alleged a claim as a mistake that would prevent the court's consideration. That would permit the court's consideration. Notably, Springfield has not even argued mistake in any pre-litigation correspondence between counsels, and it did not allege or argue mistake in its motion to dismiss briefing.
Well, how did it come up then?
It came up in the answering brief. That's the only place it was briefed.
It was never mentioned in oral argument?
It was mentioned, this mistake was mentioned just as I think a factual issue in oral argument under the motion to dismiss. No briefing took place, and it wasn't argued in the motion to dismiss or any other briefing to the trial court. In fact, in the motion to dismiss, counsel for Springfield really just argued just the opposite, that a written release in any form was not necessary to effectuate a settlement with plaintiffs. So release or the underlying issue of release were never argued, at least in terms of a mistake. The second reason that prevents the court's consideration of reformation is that Ms. Sanders, who was a party to the release agreement, is not a party and was not a party in the action or on this appeal. Thus, any reformation of the agreement would not be binding on her.
True, but why would that prevent us from, why would that make the court's ruling in error?
Well, it wouldn't be effective. If Ms. Sanders...
But is that our concern, or is that concern potentially for another day?
Well, I think it's essentially becomes moot. So I think if you're going to reform a contract that has no effect, I don't know what the point of why we're even here and discussing it.
What would be if it would have effect to the other parties?
Well, to the extent that you would reform and add plaintiffs as a party, they couldn't use that reform contract to collect any of the proceeds that were paid to Ms. Sanders. She was not a party to this action. It wouldn't be binding on her. So the plaintiffs would be left essentially with nothing. They'd be left a reformed agreement. They were parties, but they have no ability to collect any of the lump sum payment that was paid to Ms. Sanders. Essentially, then, you're asking the plaintiffs to release their claims for no consideration.
Would they have a cause of action against her?
Of course not. Why would they have a cause of action against her? The Reformation, she's not a party to the Reformation. The Reformation was done in another court. She's not a party. That Reformation is not binding on her.
Well, let's back up to what was agreed to. What was agreed to? What's the essence?
What was agreed to was in the written release.
Was it?
Yes. That's
That's
what was
not what
signed.
the trial court found.
No, the trial court didn't find that at all. The only thing the trial court found was that the release was not necessary for loss of consortium claims. Those claims are derivative of the injured parties' claims, and
I thought the court also found it was a Rule 80
no,
agreement.
the court did not find that. Initially, in the initial ruling, the trial court found Rule 80 applied on a motion for new trial.
Okay.
That argument was made. The court explicitly said that it ruled in error, and Rule 80 was not applicable.
Go ahead.
No, your clients presented evidence showing that it was never agreed upon, that your clients, when I just say your clients, never agreed to accept $350,000 in full settlement of the claims. Are you suggesting that?
I'm suggesting
where is that in the record?
I see no evidence. No evidence was presented. Again, we had a motion to dismiss.
You're saying you
There was
presented evidence?
no evidentiary hearing.
Okay,
So there's no evidence
You're saying the
presented.
lack of it. I'm saying, where did you affirmatively prove that was not the agreement?
The written release is the written agreement, and that's the agreement among the parties, is the written release. I think it's clear there were some preliminary negotiations. There were some preliminary terms that were, I think, formed the basis, but there was no agreement. The last confirming email to opposing counsel was that the payment term, $350,000, I think, was agreed to. With that, and then the structure of the payment was going to go to Ms. Sanders' counsel, and then the last section of that email was provide release terms, propose release terms. And then those terms were proposed, they were revised, they were then executed by Ms. Sanders, and only Ms. Sanders. So that superseded anything that occurred prior to that. That's certainly in the parole evidence rule, is that you got a final written expression of the parties' agreement. That's the written agreement. I mean, that's the agreement of the parties. That's what Ms. Sanders agreed to. And frankly, my third point is that the plaintiffs never agreed to those terms. We have no written agreement. They weren't parties to that written agreement. The only parties to the written agreement was Ms. Sanders and Springfield. I find nothing in the case law that allows Reformation to add a party. As far as the court knows, the plaintiffs have never even read.
Add what party?
My plaintiffs, my
Okay,
clients.
okay.
That's Reformation. Is
Multiple parties.
or any party. Adding a party to a.
If there's unilateral mistake, there's case law directly on point.
To add a party, I think there's directly on point to modify terms.
To reform a contract.
To modify the terms or add the terms. I find no case law that allows
Okay.
Reformation to
Fair enough,
add
yeah.
a party who is extraneous, who never executed the written agreement.
Okay, so counsel, I'm looking at the email communications that have been referenced here in your argument, and I see that on June 10th, 2019, Springfield's counsel sends an email advising you that he's the person negotiating the settlement, explains that the $350,000 offer to settle would expire 1 week from a conversation that you've had, which was May 12th, and explains that the offer to settle is inclusive of all liens which must be satisfied as part of the settlement. And then your response the next day is that the Sanders, plural, have instructed me to communicate their agreement to settle their claims in this matter for $350,000 inclusive of all liens as you specified below. And then you say, please provide a proposed written release of their claims for review.
Yes. So that I think that evidences there was no final written expression until we had the release. And the final written expression was the release that was eventually executed only by Ms. Sanders. if that was
Okay,
the,
just a moment. Let's just go one step at a time. So the instruction you gave was to provide a written release consistent with this discussion that you've just had, right?
well, I don't know if it was an instruction. It was certainly an invitation. I think it evidences that there wasn't any final agreement, that we obviously needed something in writing and something
Okay, your
signed.
words is that the Sanders have instructed you to communicate their agreement to settle the claims consistent with what has been specified below. That's what your email says. My question is, are the terms in the release that Coetta Sanders signed, are they the same as these terms indicated in the email?
They're not the same in two different respects. One, the plaintiffs were omitted, and two, the release, well, the terms that what's very important to my client, to Ms. Sanders, not my client now, was that they were
all your clients, weren't they?
At that time,
And
yes.
you were negotiating on behalf of all?
I was negotiating on behalf of all of them. But a very important term that was in the initial conversation that was contemplated was that the entire lump sum was to be paid to plaintiff's counsel, Ms. Sanders' counsel. There was going to be no holdback for the medical lien holder. That was an extremely important term. That term was omitted from the written release that was proposed.
So what were the Sanders agreeing to when you sent this email on June 11th?
Payment of $350,000 directly to their counsel. And
when you say
no holdback.
When you say there, you're talking about Coetta Sanders and the other plaintiffs at issue here.
Yeah, but I don't think, with all due respect, I don't think I get hung up on whether they had counsel or not. I mean, there was no...
No, I'm getting hung up on whether you were speaking on behalf of the group or on behalf of Coetta Sanders. That's where I'm...
Even if I was, and I don't think it's an important point for the effect of the release agreement, because even if I was thinking we're going to get something entirely different, and my clients maybe had something else in mind. Plaintiffs in particular might have had something else in mind.
But it goes to the fact that Springfield is negotiating with you, and you are representing that you're negotiating on behalf of a group of people, and now that the release comes to you, now you're taking a position that that was a release for one person only. So it absolutely matters.
The reason I'm taking that position is because the release only had one person on it.
And you thought that Springfield wanted to give a more beneficial offer because it's more beneficial than what they had turned down before.
Then that's a nuance that I wouldn't concede. No, not necessarily more beneficial. Again, Ms. Sanders was expecting that the entire lump sum would be payable to her counsel. She could negotiate with the lien holder. That structurally changed in the release that was proposed and what's eventually agreed upon.
All right.
That lien holder, they made a held back of $150,000 for the lien holder. That's a very important consideration I think the court has overlooked and Springfield has overlooked. They've just essentially glossed over and said, well, that's not important. What's important is the plaintiff's got admitted. No.
Does the parole evidence trump equitable reformation?
I think it trumps, yes, if you have a final written expression that, you have to have a mistake, and you have to have a mistake of fact. You can't just have any kind of mistake. That is my fourth reason, if I can get to that real quick.
Okay, go ahead.
We're kind of left with what the mistake was. I've never seen it in the briefing. I've never really heard an oral argument what the mistake was. The final sentence of Springfield's answering brief said that the mistake was essentially a unilateral mistake of fact by Springfield's counsel. I think they're conceding that it has to be a mistake of fact. It's not a mistake of, well, I forgot something. There's no explanation, no details of what that mistake of fact was in any of the briefing. I think we're kind of left to speculate what it was.
Isn't it pretty obvious it's omission of certain parties that had been negotiating,
Well,
that you had been negotiating on behalf of?
What's the mistake, though? What's the mistake of fact?
Leaving them out, an omission.
How did that happen?
Well, don't you say...
What does it matter how it happened?
Well, because it has to be a mistake of fact, not just a mistake, well, I didn't draft it. my speculation leads to, counsel never read the release that he supposedly drafted. He never read it multiple times. Not when he proposed it, not after I made revisions to it, and not after he had a chance to review the revisions and even issue the payments. All of that suggests that he knowingly drafted the release with just Ms. Sanders in it. That's a fair, if we're going to speculate, why don't we speculate like that? I don't think we can just assume, that's not a mistake of fact. That's a mistake of duty and competence and diligence.
Regardless, okay, so assume you're correct. Were your clients aware of this? Were you or your clients aware of this omission?
I'm not going to speak to that. I don't think this is an evidentiary hearing. And if we want to get
There's never been an evidentiary hearing.
Exactly.
Did you request one in this case?
Well, even if you answered it, it wouldn't be evidence. You're counsel on the case, so.
I would agree. We don't have any evidence, but.
So can you answer the question?
I think we first have to get to whether there was a claim made. I don't think we ever get to evidence unless we have a claim.
Well, let's assume there was raised, and it's been raised now by this court.
And you want me to testify now whether I knew that it was, I didn't know if it was a mistake. I specifically said in my demand letter.
I'm not asking you to testify. Okay. This is argument.
Let me stop for a second. Let me stop for a second because you said in the oral argument on Springfield's motion to dismiss, when the court asked, how is this not really a game of gotcha? And you said, because I represent my clients, he represents his clients, this is an adversarial process, I don't represent Mr. Cox or his interests, and I'm not there to protect his clients. And then you say, and the mistake was his. What mistake are you talking about? If we don't know what mistake is involved.
Because in oral argument he started out, he said, I made a mistake. He never explained exactly what.
Well, you also say, you don't just say that part, you say, and the mistake was his, and it was to the detriment of his client, but that's not my responsibility. My responsibility is to my clients. You don't seem to be questioning what the mistake was. Everybody seems to know what we're talking about here.
That's because he said, starting oral argument, I made a mistake. So he conceded the mistake. I mean, it's tough for you to say, well, I'm not going to say, well, you did make a mistake.
Okay, then I'll keep reading. Then you say, if I drafted something in a release that he didn't include in there that was detrimental to my clients, I would be breaching my duty of loyalty to my clients. You're referring specifically to the mistake we're all talking about, which is drafting a release that didn't include in there.
But that's not a unilateral mistake of fact. It's not a mistake of fact.
No, I'm just speaking to the fact that you said we don't know what mistake we're talking about here.
Well, again, I'm not talking about that there was an omission of plaintiffs from it, but what was the underpinnings of the mistake? What were the mechanisms of the mistake? If it was, I didn't know that plaintiffs were around, okay, well, that might be a mistake of fact. I didn't understand what the release said. That might be a mistake of fact. I didn't read the release. I never read any revisions of the release. That's a mistake of duty. It's not a mistake of fact.
What case law do you have on to support that?
Well, a mistake of fact, I think I cited it in my supplemental brief.
Mistake of fact versus mistake of duty. Is there something you can...
I think a mistake of fact would be to, yes, I think it's cited in my brief. It's under the restatement. A mistake of fact would be to some underlying basis that formed the contract, such as plaintiff's existence. Did we misrepresent or were they unaware of plaintiff's existence? That would be a mistake of fact, something basic assumption underlying the contract.
So let me ask you, just so that I can understand a little bit better. You are representing to Springfield that you're negotiating on behalf of multiple parties. Is that part correct so far?
Negotiating, yes. That's clear. I think that's in the answering brief. I think they were clear.
After the communications back and forth, when you end up saying that that the Springfields, plural, have instructed you to go ahead and make the request for the written document, and you receive the document, for the settlement agreement from Springfield, and it only has one of your clients' names, why didn't you say anything about the rest of your clients? Why about where they stood?
Why would I say anything about my other clients?
Because you had asked for an agreement that encompassed all of the people you were representing. Didn't it seem odd to you that you had an agreement for one of your clients and not all of them?
I wasn't going to question, if it was beneficial to one of my clients, Ms. Sanders, it was beneficial to, at least that one term was beneficial to Ms. Sanders. This is a commercial transaction. I think we got to get out of the litigation context and say that, well, I had some sort of duty to instruct him or to inform him. This is a negotiated commercial contract. If Ms. Sanders was not represented by counsel, would you say the same thing to her? Is that, well, we proposed all this and you sent me a release?
Well, I'm saying the same to a person who is licensed by the Arizona State Bar
But I
and
was-
maybe leaving his other clients in a lurch.
Well,
You have a duty to all of the people you're representing, do you not?
and I don't think that's an issue here. I don't think my other clients are here as plaintiffs now. They weren't, parties to the release. Whether they wanted to be absent from that release, I think that's, attorney-client privilege, and those are discussions. And if they had a complaint against me, they can bring it against the bar. I don't think it's,
I only bring up the bar because you brought up the circumstance of a person representing themselves and how that might be handled. So I wanted to highlight the fact that this is not that.
But, well, I know, but in any commercial, in many commercial negotiations, the parties might be represented by counsel. I don't think they're acting as an officer of the court. I don't think they have they might have fiduciary duty to their client, but I don't think they have a fiduciary duty to opposing party to act under some sort of ethical duty to make sure that everybody gets all the facts right or drafts the agreement that's fair to all the parties. I don't think I have any responsibility that he draft a contract that's advantageous to his client. I think I'm under the duty to make sure that my client, understands what they're executing and that they are in agreement with it. And I think the court has to assume that Ms. Sanders was satisfied with her part and the plaintiffs were satisfied with the position they're in now.
All right, thank you, counsel. I see that time is up.
Can I reserve any time for rebuttal?
I'll give you 2 minutes.
2 minutes? Thank you.
Good afternoon. Dean Cox for Appalachia Springfield Community Association. I have an outline of what I would like to cover today, and I know there's only 20 minutes, but I'd like to start out simply by addressing something that was just said and has been said numerous times, which I believe is a very inaccurate statement of the record and in what has transpired in this case. In his argument this morning or this afternoon, counsel stated that it was never brought up to him or otherwise argued at any time prior to the instigation of the litigation in correspondence or emails or otherwise that I had admitted to him or otherwise mentioned to him that I made a mistake in leaving these 3 people off at the release. That was said this morning. If you were to look at item number 39 to our record, page 17, which is the oral argument on the motion to dismiss, you can see there that Mr. Hill made the same argument and made the same comment that I'd never brought it up before. He had no idea I was taking that position. And in fact, in his reply brief in this court, he takes it even further. And he says, speaking to us about a letter that I had written to him in November of 19, which was weeks before he ever filed the suit in this case, that I had written him a letter and I had never brought up the fact that there was a mistake on our part or that I was seeking reformation to get the other people to sign the release as we were supposed to do because we'd agreed to it. And he says in regards to me not doing that with regards to that letter, if SCA's counsel was going to admit his unilateral mistake and request equitable reformation of the release, this response letter would have been the appropriate forum for him to do so. Well, lucky for us, we have that letter also in the record. And it is item number 8 in the record, and it is attached to that as Exhibit G. And on November 25th, 2019, I wrote to him and explained to him why we had a binding settlement agreement on behalf of all of the parties. And I said, all that remains to be done is for your clients to sign the release in exchange for the money that they've already been paid, and said the following: "Certainly under the circumstances, listing your client as a single woman was an oversight by my office. It does not change the binding settlement agreement that was already in place, nor does it alleviate the rest of your client's obligations to sign the release. Quite frankly, it was incumbent upon you to add the names of your remaining clients into the release at the time you initially struck from our proposed release, quote, a single woman, unquote, when referring to Coda Sanders. I will also say that I am quite alarmed by this rather brazen maneuver on your part. I have included with this correspondence a release to be signed by John Sanders, Lori Vanberg, and Robert Sanders. Please be advised, and please advise your clients, that one of two things is about to happen. First and most appropriate would be that your clients, I'm paraphrasing the three names, will sign the release and return it to my office, at which point we will conclude this matter and simply let bygones be bygones."
Counsel, what about Mr. Hill's argument that this is not a mistake of fact, but more of along the lines of a dereliction of duty?
I'll be happy to.
What is the mistake of fact?
I'll be happy to address that. Can I just make one more point, and then I promise I'll jump to that, just so I don't lose my train of thought?
Sure.
The only thing I other wanted to point out is with regards to his notice, is that he wrote back to me in item number 8 in the record, Exhibit H, and admitted in there on page 2 that he had had the discussion with his clients about this mistake and referred to it as a favorable term that the release only included Mrs. Sanders. And then he went ahead and filed suit. So what constitutes the mistake? I'll be happy to address that. The case that this court brought up in terms of mistake is the Isaac versus Massachusetts indemnity case. And that case quite clearly sets out the standards for what needs to happen in the event of a unilateral mistake, and requires that there needs to be an agreement about parties as what should happen, that one party makes a unilateral mistake, that the other party is aware of that mistake, and then acts inequitably to take advantage of that mistake. Now, the important point about the Isaac case, it was a rent-a-car case in which Mr. Pulitzer rented a car from Hertz. And he did not tell Hertz that the car was actually going to be used by someone else, Mr. De La Rue. And he signed the agreement. The agreement said he was the only driver, and then got insurance on that basis for the car, on the basis that he was the only driver, and then took the car and gave it to Mr. De La Rue. Mr. De La Rue was in an accident and was killed. Then when the claim was made for the insurance on that policy, it was then brought up saying he didn't know that the agreement would have only included him and not included Mr. De La Rue, and therefore he sought reformation. The court in that instance referred to it as a mistake and said, if Hertz had known that the car was to be driven by Mr. De La Rue and failed to incorporate that fact into the agreement, then reformation would be in order. Reformation is a remedy designed to correct a written instrument which fails to express the terms agreed to by the parties. And they found that this was a mistake. They found that the parties had not agreed to Mr. De La Rue, and that Hertz had no idea, and so they didn't allow the reformation. Now, if we take that case and then look at the case of Balmer versus Gagnon, which was also cited by both parties, it's a very similar circumstance with a difference, and this is where you see the difference between a mistake and what he's talking to about neglect or abuse of duty or that kind of thing. Once again, we have a personal injury claim involving an automobile accident, and the would-be plaintiff in that case hired an attorney to help him make the claim. The initial thing that happened was that they made a claim for the property damage, and in exchange for that, when the release came, the release dismissed the entire case, including any personal injury claim. They had a discussion about that between the attorney and the client. They read the agreement fully and understood that that's what it said. And then in that conversation, the attorney said, yeah, it shouldn't be there, I'll take care of the excess verbiage, and then didn't. In that case, the court said, okay, here there is no mistake, because the person who's claiming to have made the mistake completely understood the agreement, knew what it said, and then failed to execute on what he was supposed to do. And they also found, as every case that has been cited by either party found, there was no inequitable conduct on the other party's part because, and therefore, I mean, there will be no reformation. So the distinction I would draw to answer your question was, if you don't understand the terms of the agreement, they will consider that a mistake. If you do understand the contract, it's no longer a mistake. Then it's just neglect for failing to act.
But are you saying you didn't understand the contract?
That's exactly what I'm saying. For reasons
How so?
I understood who was supposed to be in the contract. For reasons I can't explain, I had a blind spot as to the fact that only Coda Sanders was there. What other explanation could there be? I mean, if we're arguing, I will argue there is no possible scenario I can come up with where any attorney, including myself, would settle a claim on behalf of 4 people and then intentionally leave 3 people off.
But if it was that clear that it was a mistake, as you suggest, and that you conveyed that to Mr. Cox, why wasn't this brought up as an affirmative defense, a mistake referendum? Why wasn't it brought up? Why wasn't it properly raised? It seems like we're really coming in the back door here through references made at oral argument before the Superior Court. We're talking about things that have never really been briefed in the Superior Court, or well, at least weren't until we sent it back for further findings or further proceedings. So what's your explanation on that?
Well, we didn't file an answer in the claim. We filed a motion to dismiss. And
Well, it wasn't raised in the motion to dismiss either, was it?
yes, it was.
Reformation?
The fact that I made the
Unilateral
mistake.
mistake?
Yes.
That was raised.
The fact that I made the mistake was certainly raised. And it's in the record.
At what point was reformation raised?
I don't know that it was. But it was raised in the correspondence beforehand, and I would point out to you that the rule
But
not...
let's go back to this. I mean, this court is, you're probably familiar with this court. We regularly and try to be uniformly consistent, and we don't allow new things to be brought on appeal that have not been raised in the Superior Court. Why is this situation different?
Well, I will tell you, with regards to raising the issue, I would cite to the court the case of Fruth, F-R-U-T-H versus DeVito. And the cite on that is 26 Arizona App 154, 1976. And in talking about Rule 9b, they say the purpose of this rule is to eliminate surprise at trial and allow issues to be developed by an adversary exchange prior to the trial. The case goes on to state, appellants argue that the mistake could only have been raised by appellees through the use of a counterclaim. We do not find that to be the case, since it seems clear that mistake may be shown by parole proof. And that's Fruth at 157. It also cites the case of Spudnuts, S-P-U-D-N-U-T-Z versus Lane, 131 Arizona App 424, 1982. If the point of this is to put him on notice, he was on notice of the mistake and my request to reform this matter by giving him the letter and the releases and everything else 3 weeks before he ever filed the lawsuit. There is no surprise, and it meets the requirements as set forth in Fruth. With regards to the unilateral mistake, I think this case fits squarely within the provisions of Isaac versus Massachusetts indemnity that was cited by this court already. And I will state that the trial court on remand found by clear and convincing evidence that it was the intent of all of the parties to have the family members included in the release, that a unilateral mistake was made, that counsel was aware of that mistake by clear and convincing evidence, and that he acted with inequitable conduct to take advantage of that mistake. I think all of that fits squarely within the boundaries of Isaac.
Are you aware, I think Mr. Hill, you can correct me if I'm wrong, but I think Mr. Hill was suggesting that he's been able to find any case where reformation has added parties as opposed to clarifying or adding terms. Can you point us to a specific case where an additional party has been added to reform the agreement?
The problem I have with that question, Judge, is I haven't found a single case that allows for reformation. Period. I haven't found a case not only where they're asking that, but on any subject, if you look at every single case that was cited by either side in this, and there's numerous cases, there's not a single one that allowed for the reformation, which shows you it's quite unique. Now, the reason why it's quite unique is there's also something else that every single case cited by either side has in common, which is that there is not a single case which found that the other party to an agreement, the party opposite the one making the unilateral mistake, was found to have been aware of that mistake and acted inequitably. There is not one case cited by anybody with that fact pattern. So is there a case that says reformation is possible because of adding a party or not adding a party? There's not even a case that allows reformation because nobody has found the inequitable conduct.
I mean, the principle has been stated, but in practice, like in the Isaac case, you're saying it was just the principle was stated.
The principles are stated,
Yeah,
that is
right,
correct,
yeah.
but we have not seen a case which shows you how unique the behavior in this case is that there is not a single instance of a case showing where one party took the egregious step of saying, I see that mistake, which has been found to be the case here, and decided to take advantage of it. And without that inequitable conduct, there isn't a grounds for reformation, and so, no, I don't have a case on that issue. Would you like me to address the settlement of the main claim and what consequences that has on the derivative claim?
Yes.
Arizona law is quite clear on the issue. The case we cited, and has been cited and relied on by everybody, is the Villarreal case. And quite clearly, Villarreal states that defenses good against the primary claim are good against the derivative claims. And they go, in that very case, they say the settlement of the primary claim extinguishes all the derivative claims. And we could leave it there to say, well, that's pretty straightforward, but much ado has been made to try to complicate that very straightforward issue because it rests with us and it settles the matter. There's no question that Cota Sanders settled her claim, and so if we follow Arizona law in Villarreal, we find that when she did that, she extinguished all the other claims. To flush it out and then talk about how it gets explained later, there was actually three things that, with regards to the Villarreal plaintiff in that case, the court had to decide. One, do children have a cause of action for loss of consortium with a parent? Two, how do we deal with the varying statute of limitations between the parent's 2-year statute of limitations and the fact that the children have till their 18th birthday plus 2 years? What happens when the case comes later after 2 years? And three, does the settlement extinguish the derivative claims? What the court said is, as a matter of law, they recognized that children do have a loss of consortium claim. With regards to the statute of limitations issue, they said, we hold that the children do have till 2 years after their 18th birthday, but that in order to get things finished altogether, a defendant could ask for joinder and bring them forward into the present action so that it could all be handled at the same time. But if they do not, then the typical 18th birthday plus 2 years statute would apply. And then they said, but unfortunately for them, these children, their claim is still, they have a claim, it's still timely, but it was extinguished by the settlement. Now, there's been a lot of talk in writing and the pleading back and forth about how complicated that is, and then the Martin case comes along, Martin versus Staheli, and it's basically the same kind of an issue in which a parent has a medical malpractice claim. He then dies of unrelated causes, The wife, the surviving spouse, moves to substitute in the estate for the deceased, and then after 2 years, the children bring their loss of consortium claim. And that court doesn't disagree with Villarreal. It comes to a different result, but affirms Villarreal and says the very same three things: that these children have a loss of consortium claim, that they're allowed to bring it after the 2-year adult statute of limitations, and unlike Villarreal, because the wife timely moved to substitute in the estate, their claim is not extinguished so that they can go ahead and do it. But it doesn't change the fact that the settlement in the Villarreal case extinguished their claim. And in reaching that opinion, the Martin Court also references two other situations to illustrate what they're talking about. In the Meridian construction case, it was an injured worker who accepted workers' compensation, and they said by doing that, he's immediately extinguished his wife's loss of consortium claim. And then in a case very similar to the Martin case, they cite Stengel versus Medtronic, where after the pendency of the litigation, the plaintiff died, and the wife didn't substitute in the estate. And under that circumstance, they said, well, normally there would be a loss of consortium claim here, but when you failed to timely substitute in the estate, the case went away, and so did the loss of consortium claim. And so our point is that Arizona law is not complicated. It says, and by the way, to distinguish, we have all adult plaintiffs in this case. The only question is, they brought a timely claim according to the statute of limitations. Was their claim otherwise extinguished? And according to Villarreal, yes, it was, the moment that Cota Sanders settled her claim. I hope I've answered your questions.
Yes, thank you, counsel.
A couple points on rebuttal. Exhibit G, the response letter that had a proposed release in it. He starts out, well, I don't think you understand the law. I think he said that somewhere in there. And I think he's referencing Rule 80. That was his argument on the motion to dismiss, is that if we were in litigation, Rule 80 would be if counsel had some sort of agreement on writing, then that's binding on the parties. I think that's why he sent this proposed release out. And importantly, that proposed release had my clients on it. I when we read that today, it lists on there my clients, and it says in exchange for $200,000, you're releasing your claims. My clients never got $200,000. Quita Sanders got $200,000. That was her money. That was payable to her. That's in the record. That the cover letter for the payment specifically directed it for payment for release of Quita Sanders' settlement. My clients didn't have any entitlement to that money. He's asking them to sign a release now in which they received no consideration. The Isaac case, I think it speaks to misrepresentation. If we had misrepresented that plaintiffs were not even in existence, well, then that might be something that would be a mistake of fact. The Palmer case, I think that's what it was, where reformation wasn't found. I think that's a classic, just a neglect of duty. It was not a mistake of fact. It was counsel didn't read the releases, didn't ensure that his clients' interests were protected. I think that just supports that mistake. Reformation is not available. The last point, there are unique circumstances. I don't think they're that unique. There's a whole litany of cases that are cited on that loss of consortium that counsel failed to include parties in there, and the counter-argument, well, we didn't have to because we have a derivative claim. Thank you very much.
Thank you. Counsel, we thank you both for your briefing and your arguments. This matter will now be taken under advisement, and we will issue a written decision in due course. This court stands at recess.